Members of the jury, in this trial, two causes of action were tried. One was by Brown, an infant, the boy who appeared on the stand, who is suing his guardian ad litem against the city of New York, and the second is by the father of the infant against the city of New York. The actions are in negligence. The boy is suing for injuries which he claims he sustained by reason of negligence on the part of the city of New York, and without any negligence on his own part. And the father is suing for loss of services of his boy. Now, the boy is suing for $25,000 and the father is suing for $10,000. The amounts are simply the limits which, in any event, might be awarded by a jury and are not in any wise to be considered as a guide to the jury in arriving at damages, if the jury ever arrive at the question of damages. The jury itself is to assess the amount of damages which the jury concludes will reasonably compensate the plaintiffs in these actions for any damage that they sustained. These are the issues in this case. The solution of the questions of fact presented by the pleadings and proof is for you. You and you alone are to determine what are the facts from a consideration of all of the evidence and the testimony of all of the witnesses in this case. You alone are the judges of the credibility and weight of the testimony of each of the witnesses. You are not bound to take the testimony of any witness as true. If satisfied from all the facts and circumstances, you find that such witness is mistaken as to the matters testified to, or for any other reason such testimony is untrue or unbelievable. The court has stated to you what the plaintiff's claim is. The defendant, the city of New York, has denied the claims of the plaintiffs, and with the exception of the admission of the city that it did control the fence in question, the city denies the claims of the plaintiff in this case. In addition to what I have said, you should consider also any interest a witness may have in the outcome of the litigation, the circumstances surrounding the witness, and what it is that moves him to be a witness. The parties litigant are competent witnesses, although they are interested in the outcome of the trial. Of course, both plaintiffs in this case, that is, the boy himself and his father, are interested parties. They are interested in the outcome of the trials. Such interest should be considered by the jury in weighing the testimony of the witnesses. The fact that a witness is interested or has some other reason than the mere desire to see justice done between the parties does not of itself make such testimony unreliable, nor does the fact that a witness is disinterested of itself make his testimony wholly credible and believable. Such interest or disinterested witness merely goes to the weight to be given to the testimony of such witness by the jury. If you conclude from the evidence that any witness has sworn falsely as to any matter material to the issues, you may disregard his or her entire testimony. However, if the testimony of such a witness or any part thereof is corroborated by facts and circumstances proved on the trial, you may consider this and give to such testimony that weight and belief to which you think it is hereby entitled, but if you still feel that it is unworthy of belief, you may entirely disregard it. You have seen all the witnesses, and have heard their testimony, and have observed their manner and appearance in giving their testimony, and you are to be guided thereby in concluding how much weight or credit you will attach to the testimony of each and every witness. It is apparent that a direct conflict of testimony cannot result solely from defective memory or impaired recollection. In reaching your decision, you must bear in mind your instructions. Test the statements of the witnesses in the light of probability or improbability. Look for all those appearances or circumstances which indicate truth or falsity. You may apply your own everyday experience to the facts and circumstances stated and draw such inferences as you deem logical and proper, and then determine on which side the truth lies. You must consider all the evidence and testimony and all the facts and circumstances as the same have been developed during the trial, giving the several parts such weight as they are entitled to in your opinion. All the evidence and testimony recollected by the jury must be considered by the jury in reaching a verdict. You are not to be guided by the statements, impressions, inferences, or conclusions of counsel or the court, except as they agree with your recollection. In any event, the issues must be decided by you solely upon the evidence as it is recollected by you, and in this connection you are not to be influenced by any impressions.